Hello, everyone, and welcome to the Equality Act and the Filibuster event hosted by several ACS chapters, including the at-large Austin, Chicago, Georgia, Los Angeles, Madison, Northeast Ohio, Oregon, San Diego, and Washington, D.C. chapters. ACS is a nonprofit 501c3 educational organization. It does not endorse any candidate or political party. It does not take positions on pending legislation, including ballot initiatives. Views expressed by the attendees and speakers reflect their individual opinions and should not be attributed to ACS. This event is eligible for CLE. The American Constitution Society is a state bar of California approved CLE provider. This event has been approved for 1.0 hours of California MCLE credit. I would like to direct your attention, if you have that function, to the chat. It's on the ACS website at www.acslaw.org/event/ACS@large, the Equality Act and the Filibuster. All CLE materials, including the form that you need to fill out to get CLE credit, are available at that website. Now I'm going to introduce our wonderful moderator for today. Steve Sanders teaches constitutional law, family law, and sexuality, gender identity, and the law, among other courses, Indiana University Moore School of Law in Bloomington. His scholarship focuses on questions arising out of the 14th Amendment's guarantees of equal protection and due process. His work has been cited by, among others, The New Yorker, The Atlantic, The Washington Post, Federal District Court opinions, and briefs to the U.S. Supreme Court and numerous other courts. In addition to his scholarship and teaching, Professor Sanders has participated in groundbreaking litigation. On behalf of the Human Rights Campaign, he co-authored an amicus brief to the U.S. Supreme Court in Obergefell versus Hodges, which established nationwide marriage equality for gays and lesbians. A case he litigated in the Indiana Court of Appeals in 2013 led to the first published opinion by any court in the United States holding that a spouse's gender transition did not affect the validity of an existing marriage. Now I will turn it over to Professor Sanders.
April, thank you. Our topic here is actually a sort of hybrid of two issues very prominently in the news right now. One is the Equality Act. That's federal legislation that's pending in Congress. It's been passed in the House, but is stalled in the Senate. That would add significant civil rights protections for LGBTQ people into federal civil rights law. The other companion issue is, perhaps oddly enough, the Senate filibuster, which is the main thing that's preventing this legislation from moving forward. Last week, a reporter in the Washington Post wrote the following: "The long march toward equal rights for gay, lesbian, and transgender Americans, whose advocates have eyed major advances with complete Democratic control in Washington, has run into a wall of opposition in the Senate. Foundering alongside other liberal priorities such as voting rights, gun control, and police reform, legislation that would write protections for LGBTQ Americans into the nation's foundational civil rights law has stalled because of sharpening Republican rhetoric, one key Democrat's insistence on bipartisanship," that's Joe Manchin, of course, "and the Senate's 60-vote supermajority rule, otherwise known as the filibuster." Today, our three panelists will explore different facets of these issues. So let me go ahead and introduce them briefly, tell you about them in the order in which they will give their initial presentations. Professor Gilbert Gonzalez is an assistant professor in the Department of Medicine, Health, and Society, the Program for Public Policy Studies, and the Department of Health Policy at Vanderbilt University. His research examines how public policies affect health outcomes, access to care, and health disparities for LGBT populations. His research has appeared in numerous leading journals. In 2016, he was awarded the Chancellor's Award for Research on Equity, Diversity, and Inclusion for his research at Vanderbilt. Professor Gonzalez completed his PhD in Health Policy and Administration at the University of Minnesota School of Public Health. Nora Huppert is the Renberg Fellow at Lambda Legal, the oldest and largest national legal organization committed to achieving full recognition of the rights of LGBT people and everyone living with HIV. At Lambda Legal, Nora has worked on various challenges of exclusions of healthcare coverage for transition-related care, including those in state employee healthcare plans and state Medicaid programs, as well as cases challenging state policies banning trans people from obtaining accurate identity documents, anti-LGBTQ discrimination in schools, and others. Nora received her JD from Columbia Law School. And third, Stephen Spaulding is Senior Counsel for Policy and Government Affairs at the group Common Cause. He served most recently as the Senior Elections Counsel to the Committee on House Administration in the U.S. House of Representatives, which has jurisdiction over federal elections. He played a key role in the House passage of the For the People Act, testified in Congress and other governmental bodies about democracy issues, and has written several important reports, including, most pertinently for today, one called The New Nullification at Work, which examines Senate obstruction and the need for filibuster reform. Stephen received his JD cum laude from the Boston College Law School, where he was editor-in-chief of the Boston College Journal of Law and Social Justice. So those in the audience know how we plan to proceed. Each of our speakers will speak for about 10 minutes. Each of them has something that brings their perspective and their expertise to this conversation. After that, we will try to have some general conversation. I may ask a few questions of the panelists, and we also invite you to submit your questions via the Q&A function, and hopefully we will have time to, we will leave time to get to some audience questions that are pertinent as well. But Gilbert, why don't you start us off? And if you can tell us, for those who haven't followed this quite as closely, basically what the Equality Act is, what it would do, and then from your perspective as a medical researcher, why this kind of anti-discrimination law is particularly important.
Thank you, Steve. Let me pull up my slides here, and I will probably answer your questions in reverse order, just providing you about a discussion, an overview about LGBT health and wellness, and then talk about why the Equality Act is needed to advance health equity for LGBT people. And so that's my main area of research. I've been at Vanderbilt for about 6 years now, researching LGBT health and how public policy affects LGBT health. And I just want to provide a broad overview for our listeners and for those who are joining us today on LGBT people and policy effects. So just some background, there are approximately 9 million adults in the United States who identify as lesbian, gay, bisexual, and or transgender. This is probably an underestimate because this is the number of adults who are comfortable sharing their sexual orientation or gender identity. But this is roughly the size of New Jersey. And then I want to just call your attention to the Institute of Medicine report in 2011. This was the first time that the federal government recognized, identified, and targeted for elimination disparities in health and access to care for sexual and gender minorities in the United States. And there were well-documented health disparities for LGBT people, and a few of them are listed here. But what are the root causes of health disparities? Why do LGBT health disparities and even socioeconomic disparities, differences in well-being, why do they exist? The prevailing theme is what we call minority stress in public health. And this attributes discriminatory environments and stigmatizing public policies. They can really facilitate feelings of rejection, shame, and low self-esteem for LGBTQ people, which in turn negatively shapes their health behaviors, their well-being. This happens very early on and among LGBT people. It can, the main example for LGBT youth occurs in bullying in schools, but this can perpetuate across the life cycle, whether it's discrimination or stigma in the workplace, whether it's in healthcare, but discrimination and stigma are really the root causes of LGBT health disparities in the United States. And you mentioned earlier that that we recently have gained major victories. In 2015, in Obergefell v. Hodges, it legalized same-sex marriage in all 50 states. And here's just a reminder of what that rollout looked like. It's starting in Massachusetts, which was the first state to legalize same-sex marriage in 2004. In 2013, in U.S. v. Windsor, the Supreme Court case, which knocked down Section 3 of the Defense of Marriage Act, which defined marriage between one man and one woman, and this was deemed unconstitutional. And after that, we see a lot more states trickle in. But for a social scientist and for a policy researcher, we love this kind of graph because it gives us an opportunity to study the rollout of a public policy like same-sex marriage on various outcomes for a targeted population. And many studies, including several of those that we've done here at Vanderbilt, have started showing that same-sex marriage generally improves health and access to care for LGBT populations. When California legalized same-sex marriage, they saw psychological distress go down among LGBT people. There are fewer mental health care visits among sexual minority men in Massachusetts after same-sex marriage was legalized. In the state of New York, following the New York Equality Act, almost about 10 years ago, there were health insurance gains for men in same-sex relationships, same-sex couples. And then in a study that we recently did here at Vanderbilt that leverages the geographic and timing differences, we found that there were health insurance gains and better access to care for men in same-sex households. I will say of the available studies and the really good studies that are out there, we're not really seeing same-sex marriage improve health or access to care for lesbian or bisexual women who may be in same-sex couples or who may period. We haven't seen the same effects on lesbian and bisexual women, which is something that is concerning to me. The other thing is that the best available studies, there's still some mixed findings on the impacts on health and health outcomes and health behaviors following same-sex marriage. But the improvements in health insurance coverage and access to care are pretty consistent. But they're still, even though we have same-sex marriage, the headlines still tell a different story. So here are some examples from Tennessee, where Vanderbilt is located. Tennessee House passes resolution criticizing same-sex marriage. We've seen bathroom bills considered across different states. Senate passes bill giving religious protection to therapists. So what that means in the state of Tennessee is that a mental health provider can deny or reject a patient based off of their religious views. And this could potentially impact LGBT Tennesseans. These aren't stories that are just found in Tennessee, but we've seen, especially in this past year, the rise of anti-transgender policies at the state level in Arkansas and Tennessee and Texas and Florida. But these are ongoing issues that continues to promote discrimination and stigma against LGBT people. And so what I recommend is that the Equality Act be fully considered, so that way it can ensure discrimination protections, ensure that LGBT people will not be discriminated in what we call in public health the social determinants of health. These are those places where we live, work, learn, and play. It can include schools, it can include healthcare, but in order to, from the research that I see, in order for us to ensure a better health and well-being for LGBT people, we need to make sure that they are they cannot be discriminated in the workplace, in nursing homes, or in hospitals, in schools. And I think that's what the Equality Act would do, which would hopefully lead to better health outcomes and well-being for the LGBT population. Thanks again for having me join you all today. If you have any questions, feel free to email me here, and I look forward to our discussion.
Okay, great, Gilbert. Thank you. Before I turn things over to Nora, let me just quickly recap just a little more specifically what the Equality Act would do. So for many years, something called the Employment Non-Discrimination Act had been introduced in Congress that would have prohibited employment discrimination against based on sexual orientation or gender identity. Last year, the Supreme Court decided the Bostock case, Bostock versus Clayton County, which interpreted the existing law of Title VII, the existing law of sex discrimination, to also encompass sexual orientation and gender identity. An interesting twist of how the judiciary gave us something that the elected branches never could. The Equality Act would go further, though, because it would prohibit discrimination on the basis of sex, sexual orientation, and gender identity, not only in employment, but in housing, public accommodations, basically access to businesses that are open to the general public, education, federally funded programs, credit, and jury service. So it would significantly expand on the Bostock decision and make civil rights protections for gays, lesbians, and transgender people much more comparable to protections that already exist in law in areas such as race and sex. So with that, Nora, I think you have some other thoughts on this issue of the relationship between the courts and judicial decision-making and public policy like the Equality Act.
Absolutely. I think, the two sort of aspects of this question of sort of analyzing the filibuster through an Equality Act lens have to do with sort of what we have to say institutionally about the judiciary, as well as about was discussed, this sort of growing wave of anti-trans legislation that has been sweeping the states. So, the Equality Act is hugely important and monumental and long overdue. But I think, what it tells us about the filibuster, I think for everything that it sort of would achieve, even in its sort of non-compromised form, and I expect, we'll have more to say about that, sort of in the current form of the legislation, it also sort of rapidly threatens to become behind the curve, both with respect to sort of the current major focus of threats to LGBT rights, as well as being sort of behind the curve with respect to where the judiciary has been on some of these issues. And that's not to find fault with the legislation itself, but more of a commentary on sort of where the Senate is with respect to the opinions of the voting public and other institutions sort of within the US government, in large part, thanks to the filibuster. So to dive a little deeper into that, we've seen clearly the past 2 years, especially this year, but last year as well, sort of as public opinion continues to markedly shift toward sort of wide support for what we might call like the basics of LGBTQ rights, things like marriage, employment protections, healthcare, et cetera. We've seen sort of anti-LGBTQ forces respond to this sort of solidifying consensus by shifting their focus first and most prominently to this toxic wave of anti-trans bills in the state legislatures that we've seen this year and last year, and also sort of expanding the already rapidly growing ground for religious exemptions to sort of basic anti-discrimination principles. Just this year alone, depending on how you count, over 200 anti-LGBTQ bills were filed in state legislatures, most of them anti-trans specifically. And those have taken a few different forms prominently. There were quite a few that were sort of centered around a few issues. There were lots of bills seeking to criminalize the provision of transition-related care and even like social interventions, things like changing the way one dresses, mostly targeting adolescents. And then we also saw state laws targeting sort of trans student athletes, and then sort of a smattering of other issues. There were several identity document laws, several sort of state RFRA laws, as well as some sort of idiosyncratic legislation. Some of you may have seen on social media or through personal familiarity, the Tennessee law this year that in essence would require businesses to publicly post a notice if they sort of support the rights of sort of trans customers to bathrooms that correspond with their gender identity, that they would be required to sort of post notices saying that that's their policy. The Equality Act, even in its, again, sort of non-compromise form, obviously incredibly important and necessary, and would codify protections that either sort of haven't been decided or have been, but that seem sort of somewhat vulnerable. But because of the anti-majoritarian sort of nature of some of our legislative institutions, like the filibuster, the Equality Act can't really have too much to directly say about this new, particularly virulent strain of attacks on trans people in healthcare, schools, in the public, et cetera, in particular. Now, surely there would be, some indirect effect in that there are some school funding issues to be had around the rights of trans students and trans student athletes, especially with recent moves that we've seen from the DOJ. But overall, the Equality Act sort of conceptually predates this new shifting focus, this new strategy from anti-LGBTQ forces. And I also want to add the caveat that the Equality Act does have more to say about religious exemptions, certainly in its sort of RFRA piece, but with the Supreme Court, at least some meaningful chunk of the religious exemption issues are maybe going to be out of Congress's hands. An anti-discrimination law that is outpaced by the very discrimination that it's designed to address seems like a pretty stark symptom of a legislative body that finds itself outpaced by the views of the people that it's supposed to represent, frankly. When it comes to the judiciary, in some ways, LGBTQ rights are maybe an imperfect lens to analyze the filibuster because while not downplaying the very serious lurking threats in the judiciary, LGBTQ rights, or at least LGB rights in particular, have perhaps enjoyed relatively more protection in the courts, have been harmed perhaps less than other members of the sort of larger civil rights coalition, and have maybe found courts at least more responsive to public opinion than has been Congress. That's not to say that our federal courts, particularly populated as they are currently, are champions on trans rights or anything like that. Just that we are sort of idiosyncratic among civil rights issues in that in the Supreme Court, and in particular on some consensus issues among the circuits, courts have been relatively more responsive to public opinion on LGBTQ rights. Public opinion, which itself has moved quite quickly, at least when you sort of compare it to issues like voting rights and structure of democracy issues or economic justice. We saw one stark example of this this morning with the Supreme Court's denial of cert in the Gavin Grimm case, leaving in place a ruling in favor of his and trans students' rights to use the bathroom that corresponds with their gender identity. Compare with, only a few years earlier in 2016, the Supreme Court granted an order in the same case that functionally prevented Gavin from using the boys' bathroom. And that was only 5 years ago. I think we sort of see, signs that the moral panics surrounding trans people in particular, sort of the lines are quickly growing, but also quickly receding, and the controversy is moving around quickly. Public opinion is shifting quickly in ways good and bad, and in ways that sort of some courts have recognized, but Congress has not. And I should say, certainly this threatens to change as we might see sort of this shifting focus of attacks. We might also see sort of federal courts forced to go there more quickly to sort of take up the more controversial issues. And so, this might not hold true in an absolute sense. So far, it actually holds up pretty well, especially if you, as one isolated example, look at the Hecox decision striking down the state of Idaho's ban on trans student athletes. But who knows what the future will hold. But in other ways, the dramatic and relatively quick shift in public opinion on LGBT rights, or at least LGBT rights, means that this might actually be a productive lens to analyze the filibuster, because it sort of highlights how completely insulated from the views of the public the Senate has become. So much so that, at least on these issues, the judiciary sometimes functions more like a politically accountable branch than does Congress. The filibuster allows an incredibly unpopular opposition to sort of the basics, as I refer to them, to win the day in Congress, sort of leading to this absurd result in which the conservative Supreme Court in Bostock arrives at the conclusion that Title VII protects queer and trans people before the United States Senate sort of extends employment protections explicitly. And maybe that's not surprising when we live in sort of a universe in which there is essentially a nomination exception to the filibuster, which I suspect people more expert than me on this panel might have more to say about. But it might not be that surprising that the judiciary is a little more responsive to public opinion, at least on this issue. And maybe to be fair, these decisions come in part because of the pressure that sort of exists on the filibuster, and in particular as a result of quickly shifting public opinion. But ultimately, I think the effect of the filibuster is highly visible through an LGBT rights lens, especially if you consider the sort of compromise form of the Equality Act, which is this sort of more moderate, more centrist version of the bill. It's an effort by a few conservative members of the Senate to basically make inevitable what was before only extremely likely, that the Equality Act would simply never be able to address these sort of new shifting focus of the threats to LGBTQ rights, sort of pushed by anti-LGBT forces at the moment, these state anti-trans laws, and to a certain extent, religious exemptions. It's not an accident, in other words, that provisions protecting young trans people and provisions preventing broad religious exemptions are the targets in the compromise bill. The compromise form of the law would basically barely catch us up to as a matter of federal legislation, to where the courts have gotten us via statutory interpretation, and that shows how effectively the filibuster can keep Congress mired in the past. Oh, I think you're on mute, sorry.
Nora, was that my cue to transition to Stephen?
Yeah, thank you very much.
Okay, thank you, that's terrific. Stephen, you are our resident expert on the filibuster. You have worked on Capitol Hill, you're an attorney in Washington, you have thought and written and spoken about larger issues of democracy. So tell us, is all hope lost here by what we know today as the filibuster, which is this sort of 60-vote default rule? Is this what the filibuster always meant, and is it what it needs to continue to be?
Thanks, Steve, and thanks to my fellow panelists and everybody else for joining us here, and the organizers of the American Constitution Society for your work. Let me start by saying, no, I don't think all hope is lost. I think there's been tremendous on the filibuster, which is blocking progress on so many issues, and I'll get into some of the background on that. But I think there is tremendous public engagement on filibuster reform. I'd say when I really started digging in on this almost 10 or 11 years ago, it was largely viewed as sort of an inside the beltway conversation about rules and tactics, and something that people weren't paying attention to. And then I think in the last election cycle, you had candidates really talking about Senate rules reform and the filibuster, and how it is blocking so much and really dampening a responsive, representative, reflective Senate that's supposed to be working in our interests. So let me just walk through a few things about what a filibuster is. And you named it and hit the nail on the head, right? A filibuster is essentially a 60-vote, it's any tactic that slows down legislation, and as it's manifested today, it's essentially requiring 60 votes to do pretty much anything in the United States Senate dealing with legislation. And it's been reformed and changed over the years, which I'll get into. But let's just start out with sort of the Schoolhouse Rock version of how a bill becomes law. A bill is supposed to pass the House by a majority vote, pass the Senate. It technically passes only with a majority vote, and then goes to the president's desk for his or her signature. And that's what the framers intended when they established this process. There were a number of veto points. The Senate could veto the House could veto the Senate. I mean, not only veto, just not take up a bill, but ultimately, once you clear those hurdles and you pass identical legislation, it then goes to the president's desk. The Senate really, though, it operates by what we call unanimous consent. Essentially, because there's so much business, it's 100 senators, most things move through, and the Senate generally operates by what they call UC, or unanimous consent, believe it or not. But there's certain things that, of course, are put up for a vote. And absent unanimous consent, all it takes is one senator to object to something, and suddenly the threshold goes to you need 60 votes to move forward. So as used today, the filibuster really is a tactic that raises that threshold from 51 to 60 to get anything done. And it's really become totally dysfunctional when it comes to passing legislation. I think now I think people would assume that there's just this assumption that it takes 60 votes to do anything on a bill in the Senate. And that, again, is not the way the system was ever designed or was supposed to be set up that way. The filibuster, it's not in the Constitution. It was never part of the Constitution's design. The early House and Senate rule books, if you look at the early House and Senate rule books, they were largely identical, and both provided for what is called the motion for the previous question, the PQ motion. That's something that still exists in the House. And all that means is, shall we end debate and vote on a measure? And in the House, that's a simple majority question. Back in 1805, Vice President Aaron Burr decided that they needed to clean up the rule book in the Senate, because it's really this body that runs on comity, C-O-M-I-T-Y, and they don't need all of these rules. And so he cleaned up the rule book, and one of the motions that was removed, one of the rules that was removed, was this PQ motion, where you could end debate on a majority vote. Lo and behold, it took senators a couple of decades to figure out that that essentially put a huge loophole in. And if senators wanted to talk and talk and talk, they could essentially have debate forever and never actually vote on a bill. So that's kind of how that was really an accident of history. And if I could back up for a second, what I meant to say about it's not in the Constitution, and it wasn't in the early Senate. The framers considered and rejected supermajority requirements to pass legislation. The Constitution specifies a handful of instances where a supermajority vote is required in the Senate. Conviction after someone is impeached, that takes 2/3. Expelling a member of Congress takes 2/3. Overriding a veto of a bill, overriding a veto of an order, approving a treaty, and amending the Constitution. Those all take supermajority votes. Passing legislation is not on that list, not on that list whatsoever. And if you go back and look at some of the early Federalist Papers, Alexander Hamilton wrote, when they were considering requiring a supermajority vote to pass legislation, he wrote that it would be used to, quote, embarrass the administration, destroy the energy of government, and subject decisions of Congress to the caprice, artifices of an insignificant, turbulent, or corrupt junto. Some strong language there about the dangers of requiring a supermajority to get anything done. I think prophetically arguing that it would lead to complete paralysis and gridlock, and really make it difficult to get anything done. So back to the original rules. So from about 1806 to 1917, senators would filibuster, hold the floor, but it was very rare, and it was used pretty much exclusively to block civil rights legislation from getting a vote. Whether it was anti-poll tax legislation, anti-lynching legislation, fair housing legislation, all of these bills, the filibuster was primarily a tool of white segregationists who wanted to impose minority rule and prevent the Senate from acting. And so it was used really once or twice a year to block these civil rights bills. In 1917, the Senate came up with this cloture rule. Then President Woodrow Wilson, there were a number of war issues that he wanted addressed by the Senate, and finally convinced the Senate to adopt some sort of a rule to end debate. And they set that at 2/3 of those senators present and voting. And that was the rule. About 2/3 of senators up until 1975, when in 1975, it would essentially take, if everybody was present and voting, 67 votes to end a filibuster. And the filibuster was so bad back then, mind you, we're talking a couple of dozen filibusters a year, that they scrapped the 67 vote threshold. Actually, President Joe Biden, when he was a senator at the time, voted to lower cloture from 67. They set it to 60. What they didn't deal with is a provision of the rules that says the rules roll over from Congress to Congress and may only be amended as provided in the rules. Still, if you read the actual rules of the Senate, it still says it would take essentially 2/3 to end a filibuster on a rules change. All of this, which we can get into later, ultimately Article 1, Section 5 says that the Senate has the right to adopt its own internal rules and proceedings, which is how in recent years the Senate has begun performing the filibuster. As for nominations, as Nora mentioned earlier. So where does that leave us? As I said, a few dozen filibusters a year. It really ratcheted up roughly around 2009, when then Minority Leader McConnell basically adopted a new strategy of filibustering everything, by which I mean holding every single item of legislative business to 60 votes. Not just at the end of a debate, but to even begin a debate. Earlier this year, we saw a filibuster on the January 6th legislation to set up an independent commission to investigate the January 6th insurrection. That legislation passed on a strong bipartisan basis in the House. Leader Schumer brought it up as to open debate, what was called a motion to proceed to debate on that bill, and that was filibustered. Just last week, the For the People Act was filibustered there at the very opening of the debate. So we hear about the filibuster being used to promote debate. It actually stops debate from even starting by requiring a 60-vote threshold. In the case of the January 6th Commission, you had 54 senators voting yes, let's start the debate, 35 senators saying no, but because of the filibuster rule, the 35 trumped the 54 and carried the day. And when you think about the United States Senate, it's already anti-democratic by its very design. You know, in the House, each person is supposed to be equally represented. In the Senate, the way the founders set it up, each state is equally represented. We now have a situation where people in California, 39 million people roughly live in California, are represented by 2 senators. Less than 1 million people live in Vermont, less than 1 million people live in Wyoming, and yet each one of those states gets 2 senators. The Democratic majority right now the Democratic majority, by which I mean 50 senators plus the vice president, represents 41 million more people than the 50 Republican senators. And so when you put the filibuster rule on top of that and hold everything to the 60-vote threshold, it's not just a recipe for gridlock, it's a recipe for not being responsive whatsoever to legislation that is coming over from the House. You can't even start debate, and it's far from promoting bipartisanship. It's actually shutting that down, as we saw with the January 6th vote. And with the Equality Act, which passed the House last Congress, it died in when Leader McConnell was had the majority leadership in the Senate. And now we know, we can anticipate that unless it has 60 votes, it's, you know, the path is that much harder, even if it will have majority support in the Senate. That's not enough. You have to, in the 50 Senate, essentially win by 10 and get 60. So some of the options on filibuster reform that have been bantered about. One is to end the supermajority requirement of 60 votes. That's essentially what the Senate did in 2013 with nominations. At the time, President Obama's nominee to the Consumer Financial Protection Bureau, nominees to the National Labor Relations Board, 3 DC Circuit nominations were all being held up by the filibuster, by the 60-vote threshold. None of those nominees were getting any floor time, even though they had majority support. And so the Senate Democrats at the time abolished the 60-vote threshold for nominations, except for the Supreme Court. The Republicans followed that up in 2017 after essentially prohibiting President Obama from filling a vacancy for the last year of his office. The Republicans quickly abolished the filibuster for the Supreme Court and seated Justice Gorsuch on the Supreme Court. What remains is the filibuster on legislation. So one option is go back to how legislation used to pass, which was on a majority basis. You could require a talking filibuster. During that rules change in 1975, when they lowered the threshold from 67, the functional equivalent of 67, to 60, they started this two-track process where you would put a filibustered bill on one track and actually get on to business that has the requisite number of votes on another track, which greatly lowered the cost of filibustering. No one has to hold the floor. No one has to actually filibuster. No one has to say a word other than raising their hand or having a staffer send an email that says, I object, and suddenly everything stops and is subject to 60 votes. You could require 41 senators to actually hold the floor. So if you want to filibuster the Equality Act, it's not enough to just say, I object, go find 60 votes. You might actually have to go to the floor and explain yourself to the American people. And when you're done saying what you have to say, allow the majority to vote. That is one option on the table. I'll just go through three more and then turn it back over. You could change what sorts of bills are subject to a filibuster. As I said, for decades, civil rights legislation is what the filibuster blocked before it became a blanket filibuster everything. It's one reason why former President Obama referred to the filibuster as a, quote, Jim Crow relic, unquote, when he was speaking at former Congressman John Lewis's funeral last summer. So there could be a carve out for civil rights legislation. There's a carve out for reconciliation. So certain bills that deal with tax issues or financial issues are not subject to a filibuster if you use a process called reconciliation, which is quite the topic these days around infrastructure, voting rights, LGBTQ rights, whatnot. You could you could end filibusters on the motion to proceed. As I said earlier, the filibuster proponents say it promotes debate. You know, if you turn on C-SPAN, you're not going to see much debate. C-SPAN 2, you're not going to see much debate on the Senate floor. But you could prohibit filibusters on this motion to proceed, where the filibuster currently stops debate from even starting. And then last but not least, former Senator Harkin had a proposal where you would ratchet down the cloture threshold. You'd start at 60, debate something for a few days. Then the threshold would drop to 57, debate for a few days. Then the threshold would drop to 54, debate a few days, and it would then drop to 51. And in that way, you are preserving the Senate minority's right to explain themselves and to delay things and have some use that as leverage to get some input on the legislation, but ultimately the majority will be permitted to go forward. So that's where I will leave it. How would the Senate do this? It would essentially be through a constitutional option. You would ask the chair for a ruling. And if 51 senators or 50 senators and the vice president sustain that ruling, that becomes the new rule of the Senate, because the Senate operates both by its rule book and by new precedents. And that's essentially how the filibuster has been reformed twice in the last 10 years. And I'll turn it back over.
So Stephen, I think you saw the question there that was posted in chat about how can the filibuster rules be changed? And it's simple. The Senate makes its own rules. The Senate can change its own rules. And I gather changes to Senate rules are not subject to the filibuster. That just takes a majority.
Well, that's where it gets really interesting as an attorney, because ultimately, yes, a majority of the Senate gets to adopt its rules. The Senate can establish its rules. There is this issue where the formal rules may say it takes 67 senators to end a filibuster on a rules change, but if you ask for a ruling from the chair about that and you sustained that ruling, ultimately a majority of the Senate has the power to set the internal rules. And majority of the Senate has the ability to deal with filibusters blocking things like
it just seems crazy. I mean, I teach constitutional law, and it's as if we amended the Constitution, without actually amending the Constitution to require 60 votes. I gather that it would be fanciful to imagine that anyone would have standing to challenge the filibuster, to say that the Senate has effectively, like, if something only needs 51 votes to pass, and if it doesn't pass, if it gets 51 votes, it doesn't pass, that is a violation of the Constitution. Has anybody ever tried that argument, or would you ever see a case like that going forward?
Actually, Common Cause brought such a case with several members of Congress and DREAM Act plaintiffs and others who bills that passed the House with a majority vote got a floor vote in the Senate, or at least a cloture vote. You look at, for example, the Disclose Act. There's more than $1 billion in secret money in our elections after Citizens United. The Disclose Act would shine a light on that money. That bill passed the House. It got 59 votes for cloture in the Senate and failed. The DREAM Act, way back, one of the first times it was brought up, passed the House and at the time got 55 votes and yet did not get a final vote. There was an argument that nullified the votes of House members in that litigation, others with an interest in that legislation. And the court essentially ducked, not in the DC circuit, not on political question grounds, interestingly enough. Imagine if the Senate suddenly adopted a rule that said women aren't permitted to vote on Tuesdays and Wednesdays. Would that vote be sustainable? But can the Senate really adopt whatever rule that it wants and have it immune from judicial review? The court essentially said that suing the then vice president, who was president of the Senate, the sergeant at arms, the parliamentarian, there was no defendant that could be hauled into court to defend this rule. That was essentially immune because there were no proper defense. Others have tried to bring suits too. There have been senators who have thought about bringing litigation on the argument that they are subject to rules that they never adopted, never voted for. And so there have been a number of theories and a number of professors who have made the case and others who have said clearly the filibuster is not at all consistent with our constitutional design and is very likely unconstitutional. The trick is who is the proper, among other things, who is the right defendant that wouldn't be subject to speech or debate issues, but who could make some sort of declaratory judgment about the Senate rules. So perhaps there will be other litigation at some point.
Great. So we have about 15 minutes remaining in our scheduled webinar. We've had a few questions posted, and I want to toss these out to whichever of the panelists thinks they might have some insight on them. The first is, my church sent out talking points that claimed the Equality Act requires healthcare providers to offer abortion care. The audience member says that doesn't sound right if this is about LGBTQ rights. Can you address what reproductive rights, if any, are addressed in the bill? Nora, or will anybody, but I'll start with Nora, any insight into that? That sounds to me like the kind of red herring that gets thrown out about these kinds of things that has no actual basis in reality. Is there any tie between the Equality Act and healthcare provider and making some change in healthcare providers offering abortions?
You know, my best guess at what that sort of attack is trying to tie to the Equality Act are sort of the broader healthcare protections that the Equality Act would offer. We've seen some sort of moral panic around that with related to transition coverage. Healthcare protection in the way that it sort of would mean the most for trans people is in the effect that it has on insurance providers and state and private employee provided healthcare plans and sort of what they will and will not cover. But there's also been another sort of bucket of controversies over actual discrimination sort of at the point of care. I want to say it's Minton Health is probably the case that most comes to mind out of California, in which a religiously affiliated hospital scheduled a hysterectomy for a transgender man, which was sought as a measure of transition-related care, and then canceled it last minute when it sort of discovered that this was an effort to seek transition-related care.
Anything about abortion, though? Anything that could reasonably be interpreted to affect the requirements to offer abortions?
To my mind, not reasonably, no.
Okay. And then the question becomes, is this just sort of made up scare tactics, which is, possible, or is there some, far-fetched legal theory by which this might plausibly arise out of the Equality Act? I guess we'd have to wait and see. There's another question which I think I can answer quickly, and that is the Equality Act vulnerable to the same fate that the part of the Violence Against Women Act suffered of being struck down by the Supreme Court as being unconstitutional because it's outside of Congress's authority. I teach in that area, and so I think I can answer that. Some years ago, the Supreme Court struck down part of the Violence Against Women Act, which would have created a federal cause of action for money damages, essentially a federal tort law for victims of gender-motivated violence. And the court said that went beyond Congress's power under the Commerce Clause or anything else. My own reading is that the Equality Act is well within Congress's power. It's been accepted since 1965. That Congress has the power to create national civil rights legislation. This would essentially add another category of people, but the nature of the protections, employment, housing, public accommodations, and so forth, are already a part of law for other demographic groups. And so I don't think there's much question about Congress's power. We have a third question. For those, we didn't talk about it. I think maybe Nora made glancing reference to it. But the Fulton versus a City of Philadelphia case, which the Supreme Court decided last week, related to religious exemptions from civil rights laws, from LGBT protective civil rights laws. The questioner says, does the Philadelphia decision mean that claims of sincere religious belief are now basically a get out of jail free card for any form of discrimination anyone feels like engaging in? My own reading of that case is no, that actually it was quite a limited case. It was really a sort of straightforward application of existing free exercise law that the Catholic Social Services Agency won, the city lost, but it was really more on sort of technicalities of language in the city policy. The Supreme Court really didn't reach any sort of larger normative or moral questions about the relative merits of LGBTQ rights versus religion. But any of you have further thoughts or disagree with that view on Fulton?
No, I think that's accurate. I think, you know, the short answer would be sort of not yet, but who knows? Certainly we saw justices sort of laying the groundwork to eventually attempt to make that move, but Fulton itself was not quite that move yet.
Yeah, I've seen some clickbait headlines that sort of suggested this would be devastating for same-sex foster parents, and I think that's a misreading. In fact, in Philadelphia, even the Catholic Social Services Agency, if they wouldn't serve a couple, they would just pass the couple on to someone else. Gilbert, I'm curious, I'd like to come back to you, if I could, about health-related effects. So legislation like the Equality Act and other forms of non-discrimination legislation, they're important, it seems to me, for two reasons. One, to prevent actual discrimination, to prevent or to rectify and to remedy and to compensate victims who have been discriminated against. The second is sort of the expressive message that the law sends. It just sends it puts the country on record that this form of discrimination is not acceptable as a matter of public policy. Does your research on health suggest that there's a difference there? In other words, might we see, does the evidence around marriage and other things suggest that just knowing that this law exists and that the federal government has made this statement can improve physical and psychological well-being among the groups that are affected by the law, even if that the particular person hasn't had any personal experience of discrimination?
Great question. Yes, I would say that people respond to feeling accepted, to feeling welcomed, and their health and their attitudes and what we call internalized homophobia begins to change once they feel accepted and welcomed. The other mechanism is that attitudes and minds change. And so families learn about LGBT people, same-sex couples, and they become more accepting. And that indirectly impacts an LGBT individual who may be coming out to their family, friends, coworkers, or colleagues. So I think that there's a lot of things happening when a country says, yes, you're welcome, you're validated, and we want you here. It does have health impacts.
Okay. We've got about 5 or 6 minutes. Just a reminder, if anyone else in the audience has questions, please go ahead and put them in the Q&A. Stephen, I'm kind of curious for your perspective on this. Okay, so the Equality Act is not advancing because of the filibuster, because basically no Republican will, and maybe not even Joe Manchin, but at least no Republican will get on board with that. Is that just because of, and again, underscoring the idea that ACS as an organization is not partisan? I'm just asking this as a factual question. Is that because of homophobia and outdated attitudes? Is it because the Republican senators are fearful of their base? In other words, kind of what to your mind explains the reason why the Republicans insist on maintaining the filibuster related to this legislation when, I don't know if Nora or Gilbert have any data on this. My sense is that it's pretty broadly popular among the American public. What's the incentive to maintain the filibuster here?
Well, that's a great question. I don't have an answer to what is motivating those who don't want this legislation to get a vote. I believe Senator Collins might be the only Republican in previous Congresses did co-sponsor the legislation, but has decided to not co-sponsor it this Congress. Senator Manchin is also not co-sponsoring it this Congress. And so it would be purely speculative for me to guess kind of, are they trying to extract a concession on something unrelated? I mean, this sort of, it's and part of the challenges with the filibuster is that it can lead to people evading accountability questions, like, why do you not support this? If something lacks 60 votes, there might be an incentive to either way to not put it on the floor because it's not going to advance, or to put it on the floor and call the question and make people explain themselves. Unfortunately, we've seen this pattern repeat itself over and over again with incredibly popular pieces of legislation, whether it's the Equality Act or background checks on gun purchase legislation or the DREAM Act or voting rights. These proposals, in large parts, do have the support of wide sectors of the American public, including real life human beings and voters, the business community, a number of other sectors, and yet it doesn't advance to a vote. And so, I mean, ultimately, it just continues. The tactics moving forward, you'll still hear some senators say, well, I don't hear people talking to me about Senate rules when I talk to them back home. I see lots of letters to the editor about infrastructure and crumbling bridges and potholes, but nobody's talking to me about the filibuster rule. And so I think it's incumbent upon those who are seeing their these really important pieces of legislation, including the Equality Act, getting blocked. It's about tying it back to the Senate rules, and when people are doing advocacy to loop this in and say it's not enough to say that a minority of the Senate opposes this legislation when the majority of the American public and majority of senators supported it, it ought to get a vote and ought to go to the president's desk.
Nora or Gilbert, have you seen any data about public opinion support for this? I know, like with ENDA, back when the issue was simply employment discrimination protections, going back to the 1990s, Gallup was finding like super majorities of the public, 80% in favor of the principle that gays and lesbians should have equal rights in terms of job opportunities, which is how the question was worded. Now, the Equality Act would also cover public accommodations, housing, other things. It's significant expansion. Have either of you seen any reliable data that suggests that there's broad support for this? And kind of to Stephen's point, I think there's a difference between salience. Just because somebody isn't going to write a letter to the editor about it doesn't mean that they might not be supportive of the idea if you ask them. Have you guys seen anything along those lines?
I think that there's been more public opinion suggesting equal protections for gays and lesbians, the L, the G, the B, but I'm afraid that the T group in public opinion polls are not fully embracing of transgender and gender minority populations. But I'd love to hear thoughts from Nora too.
Yeah, Nora, any final thoughts on that?
Yeah, I mean, I think I don't have those sort of numbers at the tip of my fingers, but I think it's fair to say that public opinion has, very quickly solidified around, a consensus supporting sort of the basics. And indeed, to your point about salience, I think, from my memory, often they show that members of the public are surprised to learn that federal civil rights laws don't, although now many of them do, but a year and a half ago would have been surprised to learn that many of them don't explicitly protect queer and trans people.
Okay, all right, we're at the top of the hour, and so our webinar was scheduled for 1 hour, so I'm going to end it. I don't know if April, our host, is still with us. I don't know if April has anything to add on behalf of ACS. I will turn it back to her briefly and just say thank you to Gilbert, Nora, and Stephen for their expertise and insights and for devoting their time today. And I hope the members of the audience found this to be interesting and helpful to them as well. So thanks for attending. April, any final words from ACS?
Certainly. The American Constitution Society is a State Bar California approved CLE provider. This event has been approved for 1.0 hours of California MCLE credit. I direct you to the website acslaw.org/event/ACS@large, the Equality Act and the Filibuster. All the CLE materials are there, as well as the form to get your CLE credit if you choose. We would like to thank all of the co-sponsoring lawyer chapters. And I would just like to reiterate, ACS is a nonprofit 501c3 educational organization. It does not endorse any candidate or political party. It does not take positions on pending legislation, including ballot initiatives. Views expressed by the attendees and speakers reflect their individual opinions and should not be attributed to ACS. Thank you to all the panelists and the participants today. And thank you, Professor Sanders.
Okay, great.
Thank you.
Thank you, everyone. Good being with you.
Bye.
Thank you.